Good morning, Justice Petse.
Good morning, Chief Justice and your fellow commissioners.
Are you well?
Well, thank you. And I hope the commissioners are well as well.
Oh, no, we are. Thank you. Maybe you should leave the mic on. For how many years were you a High Court judge before you went to the SCA?
Just bear with me for a second.
Okay, all right. Let me know when you're ready.
Yes, I am ready, Chief Justice.
Thank you, Justice Petse. The question was, for how many years were you a High Court judge before you were elevated to the Supreme Court of Appeal?
7 years, Chief Justice, and before then I had been acting intermittently from 1997
Yes.
until I was appointed permanently in 2005.
About 7 years. To be exact, I think it was 6 years, 9 months, wasn't it? Permanent appointment?
I wouldn't seek to dispute that, Chief Justice. I
Yes.
think you're right.
Yes. And for how many years have you been a judge of the SCA now?
From the 1st of June, 2012 to date.
Yes. Tell us a bit about that environment in which you are likely to be the deputy leader. What are the challenges, if any? What kind of challenges? And what solutions do you think would help resolve those challenges?
Thank you, Chief Justice. Mindful of the fact that judges are strong-willed people, I believe in consultation and reaching decisions by consensus. And I am aware of the challenges that the SCA has at the moment, and that it has been dogged by controversy in the recent past, more relating to issues of race relations, and also having to do with the complaints or memos by junior colleagues about the treatment that meted out to them by senior colleagues. I must say that I have received words of encouragement and support from the majority of the judges of the SCA, and also including senior colleagues and who have expressed some support for my nomination and indicated that they would be prepared to work with me. And my idea is to use that amount of goodwill in a positive way to try and heal some of the challenges facing the Supreme Court of Appeal. And I believe that, one thing that one would need to tackle would be to, sensitize colleagues about the principle of collegiality. Sometimes these things, people take them for granted, and they forget about them. But when there are incidents of where junior colleagues complain about having been treated badly by senior colleagues. It is best to confront those challenges frontally and, debate and discuss them at meetings of the judges so as to sensitize judges that the judiciary has a long tradition behind it, and that some of the things are never done, especially by decent people.
Well, I think I'll step back from that one and ask you something more about the High Court. Didn't you act as Deputy Judge President at some stage?
I did, Chief Justice. I had the
I asked
privilege.
because it doesn't show. You didn't include it. I don't know whether you chose to be overly humble or what.
Well, Chief Justice, as some of the commissioners might be aware, I initially was a candidate for the position in the Constitutional Court, and the papers relating to this were prepared in great haste when I had logistical challenges because I was away from home, and I was told that I need to, in fact, I was literally with the night intervening, given a few hours to put my papers together because I was told that the office, the secretariat was going to be busy preparing the documentation to send out to the commissioner so that they have enough time to prepare for the interview. That said, I had the privilege to lead the High Court in Mthatha, which had a complement of 8 judges. I was fairly junior at that stage. I was number 7, and I was catapulted into a senior position to lead the division. I was literally thrown into the deep end, and I successfully, I would say, navigated the waters and turned the situation around, so much so that the practitioners in that division are still bemoaning the fact that I did not make myself available for the position of the JP. I introduced quite a number of innovations to ensure that the business of the court ran smoothly. And I had the full support not only of the colleagues, but of the practitioners as well. And my leadership style, if I may call it such, was one of consultation. Both my colleagues, the members of the organized profession, the prosecution, and when I took over, it was a common occurrence where, for example, in relation to criminal trials, cases had been postponed 20 times. And when I came, I said, the High Court is not a court of postponement, and that the prosecution must make sure that when they serve an indictment on an accused person, they must make sure that the accused has got legal representation. If no legal representation of own choice, they must ensure that legal representation through the legal aid was in place, so that come the date of trial, the trial would run. And there was also a backlog of civil cases, and I also, worked on that. There were a lot of outstanding judgment. I issued a notice to practitioners inviting them to inform me in writing of all judgments which have been outstanding for 3 months, and asked them to give me the name of the parties, the date on which judgment was reserved, the identity of the judge who was seized with the matter. And once I received that information, I then placed it at the disposal of the judges, and judgments started to come in thick and fast.
How junior were you? For how many years were you a judge of the High Court when you were given that responsibility?
It was only 2 years, in fact, less than 2 years, because I was appointed on the 10th of July, 2005, and in February 2007, I was given the opportunity to lead the division.
And those who were more senior, for how many years had they been there as judges?
2099, 2000, and thereabouts.
And why do you think you were given that responsibility? Please don't be humble. Just tell us the position as you know it. I think this is the only chance you have to boast openly without feeling guilty.
Well, I would say both the judge president at the time and the acting deputy judge president from whom I took over, whose health was failing him, had absolute confidence that I would be up to the challenge. And indeed, I did not disappoint.
Is it true that you were very firm as DJP?
Firm but polite and courteous. I got things done. I ensured that judges were in court when they were supposed to be, and practitioners were punctual. And if they failed to come to court on time, we reported or we called upon them to file affidavits to show cause why they should not be reported to the Law Society.
A bit of
and that had the desired effect.
The bit of investigation I did about your deputy judge presidency revealed that when it became known recently that you had made yourself available for the judge presidency of the Eastern Cape, many judges were sweating about the possibility of you becoming judge president. Are you able to explain that? Why were people somewhat concerned that trouble might be coming their way?
Well, I was not aware of that, Chief Justice. Whilst I occupied that position, I was acutely aware of the fact that, as a head of court, you are a leader amongst equals, and that each and every judge had a responsibility to ensure that the system worked at its optimal level. And of course, as I say, there were practices and systems which were put in place to ensure that judgments were not unduly delayed. So at the end of each term, I expected each judge to furnish me with a list of all reserved judgments and indicate the date on which the judgment was reserved and also the expected date of delivery of the judgment. And I was professional on how I did that. Like when I received letters of complaint from practitioners about outstanding judgments, I would speak to the judge, but in addition, I would write a letter to the judge and say, here's a letter from firm X complaining about a long outstanding judgment. I want to know from you, when can the parties expect the judgment? And if a judge said the judgment will be ready in 2 weeks, in 3 weeks' time, then I held them to that.
Now, the circumstances under which you were, as you put it, catapulted into a leadership position as a junior is somewhat similar to the situation now, isn't it? You have some very senior colleagues at the SCA that, if appointed, you would have to be their deputy leader or their leader. How do you see your previous experience assisting you in addressing whatever challenges might arise as a result of the junior level at which you are as an SCA judge vis-a-vis those senior judges that you found there, some of whom have even acted as a deputy president of the court?
Chief Justice, as I indicated earlier, I've received of support from most of my colleagues who spoke to me when I was nominated by the president. And indeed, my past experience with the High Court will put me in a better state to traverse the present terrain. And I also, draw inspiration, from the book of the Exodus, chapter 17. When God wanted to anoint David as the king of the Israelites, he sent his messenger, Samuel, to Jesse, David's father. And the father, because he had no regard or confidence in David, showed Samuel all his son from the firstborn, and Samuel said, "This is not the one." The second, "This is not the one," up to the seventh. And after the seventh, then Samuel asked Jesse, "Don't you have any more sons?" And Jesse said, "Well, there is another one, but he is tending to livestock in the field." And Samuel said, "Call that one. We are not doing anything until he arrives." And when David arrives, Samuel said, "This is the one."
On a lighter note, it was not Exodus 17. It's 1 Samuel 16. That's on a lighter note.
Yes, thank you. Yes, no, that's true. I've made a mistake. In fact, it's Samuel. I've got it here in my file.
Yes,
It's 1 Samuel, verses 1 up to 23.
Yes, no, that was on a lighter note.
Yes.
It's on verse 13 that he was anointed. President Maya.
Thank you, Chief Justice. Good morning, Justice Petse.
Morning, Justice Maya.
Are you well?
I'm still surviving, thank you.
Right. I think, thanks, Jay. I think I should place it on record at the outset that you and I go back a very long way. We are from the same small town of Mthatha, and we have known each other since we were practitioners, and we had occasion to work together at the High Court and now at the SCA. I think I should start by vouching for what you said about the efforts to get you back to the Eastern Cape to head the Eastern Cape Division. There was a very strong lobby to recall you from the Supreme Court of Appeal to go and fix matters down there when that division was floundering. And the reason for that was because the legal fraternity in that region has such confidence in your abilities as a leader that they believed that despite the time lapse that you'd been away from the division for a long time, but they still felt that you could come back and make a difference. Now, I just want to follow up on a few of the questions that the CJ has asked you. What kind of relationship do you have with your colleagues at the Supreme Court of Appeal, generally?
Well, generally, I would say that I get on well with, with everyone there.
Do you have the respect of all your colleagues?
Well, those who have taken care to speak to me following my nomination have expressed support for my nomination and indicated that they look forward to working with me in a new capacity. But I asked them not to run ahead of themselves because
And-
I still have to present myself before the JSC.
And that includes senior colleagues.
That includes senior colleagues. I'm hesitant to mention name, but one of them was the one who acted as acting president recently. He said he was missing me, that I've been away for a year at the Concord, and was pleased that the president had nominated me, and that he was prepared to, to work with me.
All right, and second to me, that is the most senior judge at the SCA. Just for
Indeed
those,
so.
Yeah. The SCA is generally run by committees manned by its judges. We have various committees dealing with finance, house issues, library, IT, all those kind of aspects that form part of the general running of the court. Have you had occasion to be involved in any of them?
Yes, I have been involved in various committees since my permanent appointment in 2012.
And what benefits, if any, have you derived from participating in those committees?
Well, I must say that I've, derived benefit from that. And indeed, when I had a conversation with the senior colleague that I've just referred to, I said that, we are all members of that court, and we owe it to the nation to make that court function at an optimal level, and that each and every one of us has got a responsibility, a sentiment that he fully endorsed.
Gender diversity remains a huge challenge in the court. And I'd like to hear from you what additional measures, if any, we could put in place to improve the situation more than what we are currently doing.
Well, I would say that it is important, and this is what I did when I was leading the High Court in Umtata, give people an opportunity to act whenever the need arose, who had potential, so as to create a pool from which appointments could be made as and when there were vacancies.
Now, to the sticky bit, you spoke of our challenge with collegiality in the court. And I think I should ask you this in this forum. I have been away in the past term. I was on leave from the court. And we had thought that things were improving. But just a few days ago, I received reports that a junior colleague or junior colleagues have had serious runs-in with a senior colleague, ugly runs-in that spilled over to being shouted at, such that people in the entire corridor heard what was going on. And I mention this because one of the junior colleagues was an acting judge who will likely go and narrate the events back home, and things get around. So there is no point in hiding our dirty linen. Now, you said that one way of dealing with this challenge, which seems to dog us, despite all our best efforts, is to confront it frontally and debating it at judges' meetings. Do you really think that is an effective measure?
Well, I believe that colleagues must be made aware when they stray out of line that what they have done was totally unacceptable. It's no use talking about, behind the colleagues and not do anything about them. The point needs to be made that a judge must always eschew controversy, and that in their dealings with other colleagues, both inside and outside of court, judges must choose their words carefully and must always be scrupulously collegial in their dealings with other colleagues. And if we, don't talk about these things as often as we can, they are not going to go away. It might be that in relation to that incident, one would have, to speak to the judge who is alleged to have shouted at the other judge, because my belief is that judges need to be made aware that in making observations just about anything, commenting on the quality of a judgment that has been circulated by another colleague, they must do so in a courteous and sensitive manner, mindful of the fact that we are different, and that one must not be judgmental, but must endeavor to understand that we are different.
And what do we do if trying to talk sense into colleagues and debating these issues regularly, what if that does not help? Is there anything more that can be done so that we do not risk having people come to act in our court, people we need?
Well, I guess, the colleagues who are at the receiving end would have then to consider, if all fails, other avenues, one of which would be to lodge a complaint if there's a basis to do so. Otherwise, unacceptable conduct cannot just be, allowed to continue unchecked. And, one would have to, to find ways and means of dealing with those situations. I'm aware that in 2017, I think it was, I was approached, because I make it my business at the beginning of each term, when there are new colleagues who have been invited to come and act at the SCA for the first time, to meet them, to indicate to them that if they encounter any challenges or any problems, my door is always open. And it so happened that in 2017, one of the colleagues, he they were in court. That colleague was a scribe, and the next day, the senior colleague approached that colleague and asked that colleague how far the colleague was with the judgment. And the colleague said, well, I haven't even begun to write the judgment because I've got a heavy week. I'm in court every day this week, and I'm doing my final preparations. That colleague went away, and the very next day, again, that colleague, went to inquire, how far are you with the judgment? Got the same answer. The third day, again, then I said, I think the best thing, send that colleague an email and tell that colleague what you have been saying the past, and that had the desired effect.
What do you think our problem is, Justice Petse? Why do we struggle to be collegial with one another?
I really don't know. I don't want to say maybe it's just, personal prejudices but sometimes I get a sense that, there are colleagues who make it their business to second-guess decisions made by the head of the court to decide who to invite to come and act there. Say, so-and-so should not have been invited to go and act and chosen above, so-and-so, And colleagues must be made aware that, there will be areas where differences of opinion are bound to occur, and that they must accept the decisions of the head of court who has the prerogative to decide who to invite.
Are there any other areas that you can think of that need improvement in the court, which I must say is, bar what we have just discussed now, is generally an efficient court?
Well, one might also need to, to look into, what's going on in the front office or admin office, because I've had experiences, two occasions when, as they dish out records for the ensuing term, and when I got home, a record which was supposed to contain 6 volumes, I had 6 volumes of the same thing, which was the Coke bundle, which meant that the other colleagues didn't have the Coke bundle. And in one appeal, I had whatever number of volumes of volume 1, which meant that my other colleagues sitting in that case didn't have volume 1. And there are also instances where, files just disappear. I remember one instance where I was allocated a petition. The applicant was self-representing, and he filed an unsworn statement, not an affidavit. Then I asked the registrar to bring that to the attention of the applicant. And on following up the matter with the registrar, the file was nowhere to be found. And it was a case where I was, my colleague and I were minded to grant leave to appeal because the sentence that had been imposed on the applicant, the cumulative effect, induced a sense of shock. And there are also other things, areas that I feel we could improve on, to allow counsel in court to argue their case without, being hampered. And that judges essentially are paid to listen to counsel argument and not to argue cases for litigants. This is not to say that judges should, when it is necessary, not debate issues with counsel or point counsel in the in the right direction, or where there is, I have in mind cases where an appeal has become moot, or where the decision sought to be appealed against is not appealable, and it would be a waste of scarce resources to listen to argument dealing with the merits if the judgment is not appealable. So counsel would have to address the anterior question of whether the judgment is appealable or not, or whether the appeal has become moot or not, and depending on how argument develops, then it might either still be necessary to go to the merits, or if the point is considered by counsel, then it might not be necessary to go to the merits.
Thank you, Chief Justice.
Thank you, President. If you could switch off your mic, please. Commissioner Mso.
Thank you. Thank you so much, Chief Justice. Judge Petse, I've been very impressed with your leadership qualities that you have demonstrated. I'm going to ask you just 3 questions that South Africans may want to know about you. One, the Honorable Singh, sitting over there, penned an article which appeared in the Independent newspaper. It was on Sunday, basically calling for the debate about the death penalty, that it needs to come back to our public discourse. What is your view on that?
Well, before I assumed duties as a judge, I took an oath of office. There is, the death penalty was declared unconstitutional by the Constitutional Court, and I abide by that. And speaking as a citizen of South Africa, my view is that before one calls for the return of capital punishment, one needs to examine whether the systems currently in place are effective. Train detectives to make sure that cases are thoroughly investigated, properly presented to court, train prosecutors, because most of the accused go scot-free either because the case was poorly investigated, either because the case was not properly presented to court, and one should rather spend resources to improve on those, and only perhaps given that citizens would be entitled to express opinions on anything and just about everything, then one would look into the question of whether the capital punishment should be brought back.
And your personal
But
view?
my personal view, I've got personal aversion against the death penalty.
The second question, Judge Petse, is that you're obviously going to now be, if appointed, the second in charge, and that is going to require you to come up with a whole lot of solutions to problems that you have touched on. Have you ever had an opportunity to develop a novel solution to a problem? What was the issue, and what novel solution did you come up with?
Well, there were many challenges that I encountered, in Umtata for the 4 years that I was heading that division. And I introduced innovations which helped, streamline the systems. I've already alluded to the fact that, cases were being postponed indefinitely because legal representation was not in place. So with the measures that I had introduced from day one, when the case came to the High Court, sat down for trial, the trial would run because legal representations was in place. And I also approached the Legal Aid South Africa and motivated for them to allow legal representatives a fee to consult with the accused who are in custody before the date of the trial, so that come 9:30, 10 o'clock in the morning on Monday, the trial runs, and that counsel do not ask for an indulgence for the matter to be stood down, for them to consult, for them to prepare either a Section 112 statement or Section 115 statement. And then the other problem that we encountered was that, accused persons who were represented by counsel of choice, counsel would have given assurance to the court that he has funds, for 2 weeks or 3 weeks, whatever the length of the trial. And it happened most of the time that, the trial would become protracted, funds run dry, and counsel would then want to withdraw. I got counsel to remain on board, to continue to avoid a situation where counsel who was on brief would withdraw when he was in fact prepared to continue with the trial on legal aid rates. Because when that happened and new counsel was appointed by the legal aid, the incoming counsel would obviously seek a postponement. It would then be necessary to have the record transcribed, and mindful of the fact that the trial had been running for 20, 30 court days, that in itself would take 4 or 5 months. And once the transcript became available, then counsel would need another month to go through the transcript. So, I got legal aid to agree to, to instruct counsel who were ready and willing to accept their rates.
And just the last question, that Judge, is for the benefit of South Africans who are listening to this interview, how would you describe your judicial philosophy? Are you conservative or are you liberal? And please furnish reasons as to why you believe you are one or not the other. Thank you.
Well, I'm not going to put myself into a compartment. I execute my judicial duties having regard to what the Constitution, the rule of law, and the law dictates. And I write judgments to deal with the issues at hand. I don't write judgments with a view to, to be seen either, as a liberal judge or as a conservative judge. When I sign off my judgment to be delivered, I say to it, go out there, defend yourself if you can, otherwise I'm out of it now.
Commissioner Mpofu?
Thank you very much. Good morning, Justice Petse.
Morning, Mr. Poff.
Thank you. Well, I think I can also count myself as one of those who regard you as an elder brother, because we both come from the Eastern Cape. But I'll talk about that a bit later. I'm going to ask you two questions which might be a little bit uncomfortable, but I'd like you to just give us answers to this. The first one might not be that uncomfortable. It is that by the time you were nominated by the president, your name had already appeared in our list of the Concord candidates. And you obviously then had to withdraw the name or keep it there. I'm assuming, and you'll correct me if I'm wrong, that that could not have been an easy decision. You probably had to take time to consider whether to keep your name on the Concord list or to accept this nomination. Can you take us through how you navigated that difficult decision, if I'm correct, and then how you came to the conclusion that you'd better serve the country or the profession by withdrawing the one nomination and accepting the other?
Well, I have to confess that it was not an easy decision, but once I have had time to reflect on the matter, I took the decision to withdraw my candidacy for the Constitutional Court and accept the nomination by the president. I would say two reasons in particular weighed with me. One, the Constitution confers powers on the president to nominate. The president represents the nation. So I interpreted that to be the wish of the nation. And I conferred with some of my colleagues at the SCA, and their view was clear, and their view was unanimous, and that they want me at the SCA.
Thank you. Well, for what it's worth, I'm happy about, I'm on record as not liking the question of vacancies, long vacancies in the Concord, but I think insofar as they allow for this cross-pollination of people from the SCA to the Concord in acting appointments, it's something that enriches our jurisprudence. My second question is about diversity. The president of the court spoke about diversity. And I want to say that your appointment, if it goes through, will obviously serve many aspects of diversity, particularly in relation to the president and you, as it were. She's a female leader, you are a male, so that might bring in some area of diversity. She was a former advocate. I know that because I did pupillage with her. And you are a former attorney, so again, that brings some kind of diversity. So far, so good. But you know, South Africa is a very complex country, and some of our issues are not spoken about. You are both from the Eastern Cape, and I now learn that you are also both from the same small town of Mthatha, as the president says. So you basically come from the same community. You speak the same language. People are not going to say this, but I can assure you it's going to come up at some stage. Do you think that that aspect of non-diversity, if you like, is something that both of you might have to navigate? If so, how? And I'll give you an example. For example, you've spoken about choosing acting appointments from across the country, which you have to do. It's always a difficult decision. You will always get criticized and all that. How can we be sure that when you make those appointments and acting appointments, for example, you're not going to turn the SCA into a Cosa Nostra?
Well, first and foremost, I regard myself as a South African, and that people out there must also take into account the fact that these are South Africans, and the fact that I happen to come from the friendly province of the Eastern Cape, and Mthatha in particular, is of secondary importance, if of any importance at all. I guess when it comes to, to acting appointments, one considers the judgments that come to our court. And for example, it would be difficult, to justify the invitation of someone, whose, judgments are, always overturned on appeal. Be it at the SCA or at the Concord, but one might have one or two judgments overturned on appeal, but that would not necessarily make one an unsuitable candidate to be considered for an acting stint at the SCA. We all of us, even those who consider themselves to be super persons, have had their judgments overturned at the, Constitutional Court. And that reminds me of what one colleague in the Eastern Cape said when he introduced judges who had attended, a funeral at his home. He said, these are the judges in the Eastern Cape. They give judgments, and this is Judge Petse, the SCA. When these judgments come before him, he overturns them. And this is Judge Madlanga, the Concord. When the judgment goes before him, he overturns the judgment of the SCA and reinstates that of the High Court. So, the point I'm making is that, the fact that you have a colleague whose one or two judgments have been overturned by the SCA does not, disqualify that person from being invited to go and act at the SCA. And indeed, that experience might be enriching for that colleague.
CJ, it's not a question, just a quick follow-up. Yeah. Justice Petse, I wanted to answer my question specifically with regard to the sensitivity that I raised. How will you navigate and ensure that there's transparency and that whatever suspicions might arise from the fact that you and the president come from the same community does not, that those suspicions are allayed, so to speak?
Well, I think openness would be, and transparency would be the key, And once it is known that you have got objective criteria, I don't think that there would be a basis for people to make out a cogent case, to accuse one of, favoritism or nepotism.
Thank you,
so to
CJ.
speak.
Thank you, Justice.
Thank you. On a lighter note, Justice Petse, it used to concern me that I was Chief Justice, Moseneke was Deputy Chief Justice, and when he left, Ngabinde, who is actually Mutsatsi and Mutswana, was acting Deputy Chief Justice. I said to them one day, this is beginning to look like Buputatswana now. Prof?
Thank you, Chief Justice. Good morning, colleagues. Good morning, Judge Petse.
Good morning, Prof.
Judge, first I have one concern plus a question. It appears that the SCA, if I may characterize it, is a troublesome court because of the issues that you raised earlier on race, complaints, lack of respect of each other. But I'm not sure how, as a leader, you can mend those faces to ensure that there's harmony in that court, because each candidate that is coming from that that is coming for that court, these issues they always come up. My question now is on your interpretation, which you have been heavily criticized, on the interpretation of the Putuma custom in the Nechituka case. I hope you still remember it.
Yes, I remember the name of the case.
Oh, okay, it's fine. My question around the case was whether the time was not ripe for the Putuma custom to be developed in light of Section 39(2), considering the fact that your interpretation was, if a man leaves his customary wives for a civil law or marriage, then the customary law marriage is suspended up until it is reinstated by divorce or a death. You were heavily criticized on that judgment. Your opinion on that one?
Well, I gave a judgment which, happily for me, enjoyed the concurrence of the 4 other colleagues, and I leave the question of final judgment on the correctness or otherwise of that judgment to posterity. And if the opportunity comes and it either goes before the SCA for it to be reconsidered or the Constitutional Court, let it be. And that's a matter that will have to be left for another day. Judges are criticized, every now and again, and sometimes unfairly, and sometimes what is overlooked, is that when criticism is leveled against judges, it is either not well informed or sometimes it degenerates to a situation where the personalia of the judge is attacked. And I believe that when one criticizes a judgment, one must just do exactly that, play the ball and not the man or the person. Thank you.
JP?
Yes, good morning, Justice.
Morning.
The norms and standards prescribe that judgments should be handed down within a period of 3 months. Is it achievable in the Supreme Court of Appeal? And if not, what would be a reasonable time within which a judgment should be handed down? And if you were to achieve that period that you are going to mention, how would you go about it?
I can assure this body that that is very much achievable at the SCA. You know, at the SCA, we work like conveyor belts. Before the end of the term, you get records for the ensuing term, which means that during recess, you read records, do research in preparation for the ensuing term. And we try our level best. The tradition and the convention has always been that this term's work must be finalized this term. So we read, research in preparation for the work which is coming, and when the term starts, we hear cases, and after the hearings, we're given the opportunity to write judgments. And those judgments are handed down. Let me not say no judgment. It takes more than 3 months at the SCA, but most judgments get finalized and delivered within a reasonable time, long before the expiry of the 3 months period.
Thank you, JP. Commissioner Norman?
Thank you, Chief Justice. Good morning, Justice Petse.
Good morning.
Good morning. I also had the pleasure of serving under you as an acting judge when you were heading the Mthatha Court. I would like to just ask, in paragraph 16.5, you've mentioned one judgment which was reserved on the 20th of November 2018. I just want to check whether that judgment has since been delivered.
If everything went according to plan, that judgment was due to be delivered this morning. It has nothing to do about my interview.
Yes.
It's the processes that judgments go through, once one has circulated.
Yes.
When my acting stint at the Concord came to an end, I made an undertaking to my colleagues there that I would circulate on such and such a date in January. I indicated to them that I was, burnt out because I'd been working extremely hard during the year, and that to avoid a breakdown, I was going to take a few days in December, which I had planned at the beginning of the year because I had not anticipated that my acting stint would be extended until the end of November. I thought that I would be back in Bloemfontein, and that in Bloemfontein I would have made sure that come the end of November, all my judgments were out.
Thank you. You penned the Maledu judgment when you were acting at the Constitutional Court, and in your introduction you mention, you say you strip someone of their livelihood, you strip them of their dignity, and this is a matter that concerned land matters, security of tenure matters.
as a judge, a justice of the Constitutional Court or justice of the Supreme Court of Appeal, when land is a topical issue as it is now in this country currently, how do you do the balancing? Because you know you have your personal views as a person, as a human being, and you still has to do your job as a judge, and the issue, you know, it affects the majority of the people of the country. How do you balance that?
Well, each case is decided on its own merits. One would have to consider the facts of the case that comes before you, the law, and the constitutional imperatives.
Thank you, Chief Justice. Okay.
Thank you, Commissioner Norman. Commissioner Didiza.
Thank you very much, Chief Justice, and good morning, Justice Petse.
Morning.
Coincidentally, I will actually follow up on the issue that Commissioner Norman has raised, maybe in a different way. In the same matter, where you were looking at the appeal against the judgment of the High Court on the Maledu case, from the way in which at the end the judgment was penned, I actually asked myself a question: doesn't this raise the issue of overlapping rights, land rights on the same land, and what takes precedent? Because on one hand is the protection of informal rights of communities where there are mining rights given to a particular enterprise. In the way in which you reflected on that matter, you indicate that there is no contradiction in both legal prescripts, but there are processes that the applicant should have followed in the manner in which he dealt with the mining rights of that particular community, but also acknowledging the rights of the communities over land. And again, in this current period where the land matter is topical in our society and there are particular decisions that Parliament has made on reviewing Section 25 of the Constitution, what would you say are the matters that as society reflects on this issue they need to take into consideration? As I say that for me, what emerged on that case is the question of overlapping rights on land between the enterprises who would want to mine and the citizens who have got rights on that land, albeit informal but protected by law, in this case, Ipilra. Thank you.
Well, the point made in that judgment is that, you know, you have the MPRA, which deals with mining rights, and you have got either the landowner who has got title to the land, or someone like the applicants in that case who had you know, rights to occupy and work the land. And the point that that judgment makes is that it is not enough for the holder of a mineral right to simply go to the owner, waiving the license and say, I've got a mineral right, out you go. The Act itself contemplates a situation, and in fact, that is prescribed, where there should be consultation, get the owner to agree to accommodate the holder of the mineral right, short of the government expropriating the land, which is provided for in the Mineral Act.
Thank you very much, CJ. Indeed, it would be an ongoing matter for debate, because if you look in rural South Africa, where land is still under the trusteeship of the state, and communities have got informal rights, and then I think the case of Kolomen in this regard becomes one interesting because it deals with these overlapping rights, and probably in future we'll be able to navigate how we manage those. But the second question I wanted to ask, I know you were lobbied, as other colleagues have said, for leading the Eastern Cape Division. I'm not sure whether you were interested, but suppose you were, what would you say is required, in your view, in that division at a leadership level to improve? I'm not saying things are bad, but maybe your own contribution would have improved that division in a particular way. What would you say from where you sit would have been your contribution had you been successfully lobbied?
Well, I must say that I gave anxious consideration to the approaches that were made by certain groups for me to accept nomination. Because time was of essence, I accepted the nomination with a reservation that I would, give my final decision whether the process would be taken through. But having reflected on the matter and considering a number of factors, then I decided to withdraw. Insofar as, it's difficult for me to say at the moment what is it that is lacking in that division. All I can say is that if all the innovations that I had introduced were to be, reinstated and possibly improved upon, then that would, put the division in a better state to deliver quality justice to the people of South Africa.
The last question, Justice Meyer. The position you have been nominated for is a DJP position, which actually is the second in leadership in that court. Given your experience, your knowing each other with the JP, how do you think you'll be able to manage those relationships? Because on one hand, both of you are leaders in your own right, and here you must find a way of ensuring that through your cooperation, you are able to lead that court and address some of the matters that indeed Justice Meyer herself had said are the challenges.
Well, by way of prelude, it's a pity that the Chief Justice is not present at the moment, because this is where Exodus 17 would fit in. I consider my role, the role of a deputy, to be one of supporting the president. You don't compete with the president, you play a supportive role. The president, in terms of the Superior Courts Act, can assign duties to the deputy, and if I were to be appointed to the position, there are matters that I would certainly look into, and then I would raise that with the president with a view to improving the systems of that court to ensure that it functions smoothly and at optimal level. And I don't anticipate ever that there would be any conflict between the president and I if I were to be appointed to the position, because I am acutely aware of the fact that mine is a supporting role, just as according to Exodus 17, the role of Moses' aides was when they were fighting a war and God had given a stick to Moses that Moses was required to raise up, and told that if he dropped his arms, then the Israelites would be defeated. And when he got tired, his aides came to his assistance. They flanked him, one holding up the left arm and the other one the right arm. And in the end, the Israelites prevailed.
Commissioner Schmidt.
Thank you, Chief Justice. In following the questions on the Maledu judgment, if I may just one more aspect on that matter. There appears to be the conflict between the MPRDA and the consensus required, and the IPILRA, which required consent. And you basically said that the two were interactive and not competing with each other in terms of what was required, because if a informal land right holder had rights in terms of where consent was required and not merely consensus. Which brings me to the question, what is your judicial philosophy? Because there appears to be a notion of, if you look at your comment with regards to paragraph 3 on page 15, written page 15, the Madibia case, where you say that restatement of the duty of the state to protect women against acts of domestic violence, the anti-protect vulnerable members of society, it then begs the question of what your judicial philosophy is, because where the state, the DMR in particular, required consensus above the board rather than consent, you were in favor of consent where informal land right holders' rights were concerned. Thank you, Mr. Chair.
Well, the IPILRA speaks of consent, and the question then arose whether the provisions of the Mineral Act should trump the provisions of IPILRA. And you know, that was not the case which was brought before the High Court. The case of the respondents in the High Court was simply that we have a mineral right, we consulted you, you don't have to agree, and we want to take over. And IPILRA accorded certain rights to informal land rights occupiers, and IPILRA in terms provided that the people who are in occupation must give consent, and that consent was never sought nor granted, and given the provisions of Section 25(6), I think it is, of the Constitution, that had to prevail.
Commissioner Faure.
Thank you, Chief Justice. Morning, Justice Petse.
Good morning, Mr. Faure.
When you were interviewed in April of 2012 for a vacancy in the SCA, which conspired to be a successful interview, you, in answer to one of the questions asked to you, you inter alia said the following: if the Constitutional Court does become the apex court and become the court of last instance in all matters, I think it would be a misnomer then to call it a constitutional court. Perhaps another name would have to be found. And I would think that the name Supreme Court of Appeal would be more appropriate. And perhaps, if that does materialize, one would have to consider whether the most suitable route would be to merge the Constitutional Court and the SCA, so that one would have, and the figures are unclear, judges in the apex court, and then it would be up to the Chief Justice, when he constitutes the bench, to draw members of the bench for each case from the full complement of the apex court, that is 35. And one would also have to debate and decide what would be the best formula, because one of the major concerns raised is that if the Constitutional Court is to become the court of last instance, then it will be inundated with work and will end up being rendered ineffective. And one knows that when the Constitutional Court sits, it sits in bank, and there is a constitutional requirement that there should be no less than 8 justices of the Constitutional Court. And perhaps if it does become the apex court, and my view were, and there's again something unclear, then one might have to consider whether in non-constitutional matters one should have a bench comprising of a maximum of, say, 5 or 7 judges to consider appeals in non-constitutional matters. I end the quote there. We know that since that interview, the Constitutional Court did become the apex court, and 7 years have elapsed since that interview, and we've seen the practicalities emerging since. My question is, are these 7 years later still your sentiments? And if so, why? Or are they not your sentiments anymore? And if so, why?
Well, that was a hypothetical scenario, and the answer, was given in response to a question that I had not anticipated. In any event, as I see it, that situation has not eventuated. There is still Section 167, which determines the question of the jurisdiction of the Constitutional Court. Which deals with constitutional matters, or I'm just trying to find the relevant subsection which says arguable points of law. So it's not every case that it's not in respect of every case that the Constitutional Court would have jurisdiction. Applications for leave to appeal are refused by the Constitutional Court simply on the basis that the matter does not engage the jurisdiction of that court, and that would then become the end. But if it were a question, if it were a question whether the Constitutional Court, in considering an application for leave to appeal, is of the view that either the judgment of the High Court is wrong or that of the SCA is wrong, if the matter does not engage the jurisdiction of the Constitutional Court, the application will fail on that basis.
So, Justice Petse, what are you saying? Are you, and I'm not saying those were your firm views, you just expressed opinions at that stage because it was something that has as yet not materialized.
Yes.
But now that it has, would you still believe that the naming may be a misnomer of the Constitutional Court, and do you still feel that there might be room for discussion to merge the Constitutional Court and the SCA?
No, sir, we were at cross purpose. That's the very point that I'm making, that the Constitutional Court does not deal with every case that comes before it. Before they entertain any case, they must first determine whether it engages the jurisdiction of that court. And there are two categories: either it's a constitutional matter, or it's an arguable point of law, not point of fact, or a point of law which is unmeritorious. So there's that safety valve which enables the Constitutional Court to determine which cases engage its jurisdiction and which cases are worthy to be heard by the Constitutional Court.
So just to understand you correctly, you are comfortable with the jurisdictional issues and the functioning of the two courts separately
Precisely.
as it emerged since the Constitutional Court became the apex court.
Precisely.
Thank you, Chief Justice.
Thank you, Commissioner Fori. Commissioner Modise.
Thank you, Chief Justice. Good morning, Justice Petse.
Good morning.
In your judgment in the Mamlambo construction, you say the following words, and I quote you, "I do not for one moment believe that I have strayed outside the parameters set by the judicial precedents, which enjoin the courts to take care not to usurp the functions of administrative agencies." Just what did you mean? And how do you ensure that in your judgments you do not usurp the functions and powers of other arms of government?
Well, the point I was making there was simply this, that the courts must not usurp the powers either of the legislature, the executive, or bodies such as I think in that case it was the municipality which had awarded a tender to a company. So ordinarily when a court finds that there were irregularities in the award of the tender, it must then set aside the award and remit the matter to the body which is, in terms of the law, mandated to deal with the tender, and not itself award the tender, except, of course, when there are exceptional circumstances.
Justice Petse, I will come back to it in another way. In the Mlungwana case, you refer to legislative overreach. And again, I want to ask, how do you ensure that you do not, as a judge, usurp the functions of the other arms? Alternatively, what do you mean by legislative overreach?
Are you able to refer me to the relevant paragraph so as to gain an insight into the context?
I think it will be paragraph 85.
Well, the point I was making there is simply this, you have got Section 17 of the Constitution, which guarantees the right to assemble peacefully and unarmed. And for as long as that constitutional provision remains, then it is not open to the legislature to enact law which contradicts those provisions.
Chief Justice, I won't pursue it.
Thank you, Chairperson. Commissioner Nogesi.
Thank you, Chief Justice. Good morning, Judge Petse.
Good morning, Mr. Nogesi.
Justice, the GCB, in its comments, note the following. The candidate is a role model, not only within the judiciary, but also in the society at large. This comment appears mostly on the comments that have been made in relation to your candidates. I haven't seen any negative comment as to start with. What I want to establish from you, this arises from the comment, the question that the Chief Justice had earlier on asked about some ramblings when you wanted to go to the Eastern Cape, maybe some colleagues not comfortable. Have you heard about that? And if any, what could
Commissioner Nogesi, we are struggling to hear you
Sorry.
here. Thank you.
Thank you, Chief Justice. What I'm saying is, in relation to the comments that I've referred to by the GCP and comments generally made by all those law bodies that have made comments to your application, what could have been the reason for some of your colleagues in the Eastern Cape to have some misgivings when you go back there if you eventually had to go to the Eastern Cape?
Well, my answer would be speculative. I wouldn't know, but perhaps if I would hazard a guess, maybe, there have been unusual things happening in some of the divisions. If you are doing duty in Umtata over the weekend, I don't expect you to go to Durban. And when an application comes through, you want to deal with that application telephonically. I can relate an incident where an urgent application was filed on a Saturday, sat down for 2:30 in the afternoon. Counsel for the respondent rocked up in court at 2:00 to oppose the application. And they were told that the judge doing duty had granted the order at 10:00 in the morning telephonically. So my point is that you had that situation where an application was opposed and the respondents were prepared to argue. And how do you argue when the judge was supposed to be doing duty is sitting 500 kilometers away from the courthouse? And I was known that those are practices that I would never have countenanced.
And Judge Petse, I also noted that from all these nominations, that is from the comments that have been made, you are referred to as somebody who is dedicated, committed in his work, and also your career progression within the legal profession itself, starting as a clerk in the Department of Justice, is consistent with somebody who developed within the legal profession. Like your experiences in relation to those that have been referred to, for instance, at the SCA, where you find out that there are some prejudices. How do you respond to that? I mean, how do you respond and ensure that we do away with this? I mean, these tendencies, they are dealt with.
Well, I've always taken my work seriously as a student at university and as a practitioner and as well, as a judge. And my belief is that if you have got a strong purpose in life, you don't have to be pushed. Your passion, will drive you to where you want to go. And I would reiterate that, one has to be seen to be consistent in dealing with the challenges besetting the Supreme Court of Appeal. And one must take a firm stand, and one mustn't avoid taking strong stand or opt for easy decisions or decisions that are popular. You'll earn the respect of your colleagues if you are known to be consistent, if you are known to take principled decisions or stands in situations of conflict amongst colleagues.
The last question. When you were the leader in the Mthatha High Court, I know as a fact you appointed persons to act in that court from other divisions, who were not even Xhosa people or Zulu or whatever. You just appointed some people to act there. Secondly, you have been in your nomination supported by national law bodies who have read your CV, who know where you come from, and if they had any problem with your candidacy, would they have not raised those issues up? Thank you. That's my last question.
I believe they would have raised those issues. My belief was that, for as long as you are a South African and you are a fit and a proper person, you should be given an opportunity to, to act. And the intention was to, to create a pool so that, when a vacancy arose, there would be fit and proper person from whom to choose a worthy person to fill the vacancy.
Commissioner Singh.
Thank you very much, Chief Justice. Good morning, Judge Petse.
Good morning, Mr. Singh.
I just want to follow up on Commissioner Msomi earlier on, when he referred to an article that I penned calling for higher sentences, etc. And he asked you your view on it. And one of the things you said is that many people go scot-free because of poor investigation, poor policing, and poor prosecutions. Now, that kind of response, and I'm not meaning you giving that response, is cold comfort for victims of families that have had young children raped and murdered or women murdered. From your experience as a judge, and you're a senior judge, what do you think really needs to be done in the South African judicial system, including in prosecutions and the police, for us to give comfort to South Africans that if somebody is arrested for a particular crime, that justice would be served in the most appropriate manner? Now, I'm saying this also in the light of the head of the NPA apparently speaking at a function recently, where she said they are short of 491 prosecutors. And we know that the police always complain about infrastructure. And I'm asking this question, Honorable Judge Petse, because we have the advantage of having the Minister of Justice here as well. And I'm sure the representatives of the Ministry of Police are also listening, because this will require a joint effort to ensure that we reduce the 57 murders a day that have been reported by the Minister of Police when he presented statistics last year. What would your view be? What needs to be done drastically? Thank you. Thank you, Chief Justice.
Thank you, Mr. Singh. I agree with you that the concern that has been raised by communities out there is a legitimate one. I am aware that, still having connections with my rural roots, that, the judiciary is is blamed most of the time for the ills besetting the country. But this is so simply because people don't appreciate the fact that courts can only convict if there is evidence or proof beyond a reasonable doubt. And short of that, they are bound to acquit. And the responsibility to gather evidence which would ensure that at the end of the day, there are prospects of conviction rests not with the courts, but first and foremost with the police and the prosecution. And those two entities, there's no reason why they should not, collaborate with each other. If it means that, the police and the NPA must be, adequately resourced, so be it. But one is mindful of the fact that there are many demands on the national fiscus, and it is up to, to the relevant portfolio committees in collaboration with the relevant ministries to come up with strategies which would address the concerns, legitimate concerns that have been raised by members of the community. Crime has reached pandemic levels, and one needs to have a multifaceted and a response to deal with the scourge of crime.
Thank you, Chief Justice.
Thank you, Commissioner Singh. Minister?
Thank you, Chief Justice. Justice Petse, I was beginning to warm up to your sentiments expressed prior to the amendment to the Constitution that Commissioner Fourie alluded to, and a little bit disappointed when you seemed to backtrack from it. But I nonetheless would still want to engage you further on that issue. Now, if you look at 167.3b Roman 2, it seeks to, whilst extending the jurisdiction of the Concord, nonetheless restrict it a bit. But in doing so, I get the sense that it still leaves the matter fairly open and vague, and I would want to hear you further on this aspect, because the last words of paragraph of Roman figure 2, it talks of course, other than constitutional matters, it talks of matters which could be of general public importance and which ought, and this is the part I'm particularly concerned about, which ought to be considered by the court. Now, which ought to be considered by the court doesn't seem to provide, or seems to give unfettered discretion on the part of the court to determine what ought and what ought not be considered by that court. And I'm raising this not purely from an academic point of view, but the sense we are getting is that that court, with South Africa becoming increasingly litigious, that court is increasingly becoming inundated with matters, and the whole issue of what that will have on the court in terms of its ability to dispose of matters expeditiously as more and more matters, turn around the question of whether they are of significance, public significance, and the whole question of, whether the court, would in all instances have it clear as to which matter ought to or ought not to be considered by it. I don't know whether you want to make any further comment in the light of that.
Thank you, Mr. Minister. The word ought to be read with what precedes it. And what precedes it is that the matter must raise an arguable point of law. So you have to overcome that hurdle first. Is this an arguable point of law of general public importance? And if you fail on that hurdle, then that's the end of the matter. And if you succeed, then the next question arises. Is it this a matter that this court ought to hear? And if the answer to that question is in the affirmative, then the Constitutional Court will entertain that case. If not, then that's the end of it. And there are judgments of the Constitutional Court to the effect that an arguable point of law means a point which has merit, and not just any point that, on account of counsel's ingenuity is presented as an arguable point of law when in fact it has no merit.
Well, if I may make a follow-up, Chief Justice, I would imagine that the concept of a Supreme Court of Appeal was to, in part, alleviate the risk of the Constitutional Court being inundated with all manner of subject matters of law, so that there is some finality at that level.
Yes.
Do you think that this provision as it stands assists in supporting that objective of allowing the Supreme Court of Law, the SCA, to be the court of final instance in as many matters as could be in various areas of law, in order to free the hand of the Constitutional Court sufficiently. Because just dealing with constitutional matters and confining yourself to constitutional matters alone, especially when you sit and bank, to me, is already placing quite a heavy burden. So that is the one leg of the question. But the second leg of the question is that did we have to bring other matters other than constitutional matters in order to confirm the Constitutional Court as the apex court? Isn't it so that the Constitution itself is the apex law, and whoever has the final say on the Constitution itself de facto becomes an apex court because they, are the final arbiter on disputes arising out of an apex law. In other words, I'm just trying to understand why justify locating or confirming the Constitutional Court as apex court by bringing other matters other than constitutional matters on that basis.
Thank you, Mr. Minister. My respectful view is that, it does not. That provision, as it presently stands, has given rise to a situation where every litigant who has been unsuccessful in the SCA, who is minded to fight this case to the end, will go to the Constitutional Court and seek leave. And the determination whether the decision of the Supreme Court of Appeal is final is made by the Constitutional Court when they receive a petition, that is an application for leave to appeal. Does this matter raise an arguable point of law of general public importance? And my experience during my acting stint last year at the Constitutional Court was that, litigants who have nothing to lose can, take their cases up to, to the Constitutional Court. And the effect of that is that for as long as the Constitutional Court has not adjudicated the application for leave to appeal, everything is at a standstill because the Superior Courts Act, Section 18, provides that if you file an application for leave to appeal, the judgment is suspended. So if you succeed at the SCA, the losing party decides to take the matter further and conjure up something and say this case raises an arguable point of law of public importance, when in fact it does not. The effect of being given that opportunity would be that finality in litigation, is compromised because matters drag on longer than would have been the case if the Supreme Court of Appeals judgment was final. So in effect, the workload of the Constitutional Court has increased in the sense that when those applications come, it's their call to decide whether any given application raises an arguable point of law of general public importance, not of importance to the litigant, general public importance. And this is what most of these applications that come before the Constitutional Court lose sight of.
Just finally, if I'm allowed, Chief Justice, to conclude this point, what advice, if invited to do so, would you offer the Constitutional Court as to how best to deal with this matter in a just and fair manner, but at the same time in a way that does not further impact on the efficiency of the court in ensuring expeditious bringing of matters to finality, especially where dilatory tactics are used, taking advantage of the openness of this provision?
Well, it's difficult to give an informed and well-considered response to your question, Mr. Minister. Perhaps the best I can do would be to say, I think this is a matter that, the Portfolio Committee on Justice should give consideration to and see whether one need to do something about that constitutional provision, and if so, what?
Thank you, Minister. Commissioner Masuku.
Thank you, Chief Justice. Good morning, Justice Petse.
Good morning, Mr. Masuku.
Yes, I have two questions. The first one is, what would you consider are your weaknesses that would require you to pay attention to? And secondly, your evaluation of the problems that confront the court together with what the President said is of some concern. I mean, the idea that some of the highest and most respectable judges in the country may be involved in what could be called uncollegial acts or even racism is of deep concern. The public would be justified to be outraged that those are the problems you identify there. I mean, what can be done in order to so is your evaluation of these problems such that you believe they are a threat to how the SCA is seen by the public? Or is it something that can be resolved, with your skillful and obviously with the leadership skillful engagement with those complex issues?
Well, my short answer would be that although these things do happen, it is not as though that, the great majority of the members of this court are, if I may put it that way, guilty of this type of conduct. It may well be that it has more to do with issues of personalities. Perhaps to use the word obnoxious, it would be a strong word, where you have people who have, unpleasant disposition towards other colleagues. One has to bring it to their attention that that sort of thing is totally inimical to the values underpinning our Constitution. And all of us as judges, take an oath of office or make an affirmation that we will protect and uphold the Constitution and the rights entrenched in the Constitutions and the values underpinning the Constitution, and that this is a serious matter, and that colleagues should be careful not to do things that might or conduct themselves in a way that might find themselves on the wrong side of the law or judicial etiquette.
Are you done, Commissioner Masuku?
Just the question about what you think are your weaknesses. You spoke a lot about your strengths, and I remember the Chief Justice saying that go to town about it. But in your evaluation of your strengths, is there something that you look at and you say maybe this is one area I could improve on?
I guess overworking myself.
That's a good habit. Chief Justice.
Thank you very much, Commissioner Masuku. Just a few things, Justice Petse. I want to go through you. I want to discuss with you your never lawful judgment that you have attached to the to your book 1 of 1. Remember never lawful? The arrest and detention, Minister of Safety and Security, Minister of Justice and Constitutional Development.
Yes.
Yes. And this is what I want to know. Remember, that matter is about the arrest and detention from 21st to 23rd of October, I think it was 2008. Which constituted Claim A. And then there was detention after appearance in court from the 24th to the 31st of October of the same year. Now, my concern relates only to Claim B, and that is the detention after the person had appeared in court. And here lies issues in relation to which I need clarification. Why was the Minister of Police held liable for the detention of Mr. Ndlovu after his appearance in a court of law? I understand about the arrest and detention that was effected by the police, the other ones who arrested him, the other one who locked him up. But then he was taken to court, the reception court. And it is the court that ordered his further detention. Why did the Minister of Police have to be held liable for the detention that flows directly from a court order?
Chief Justice, I don't have a copy of that judgment in front of me.
Yes.
But I seem to recall that the Minister of Justice was one of the respondents.
Yes, he was.
And the claim was against both of them.
Yes, that is true.
And at the end of the day, the judgment was to the effect that they jointly were liable to the plaintiff.
Exactly.
Yes.
This is why what I don't understand. What does the Minister of Police have to do with the detention of a person as a result of a court order? What role do the police or their minister as the overall political head have to do with something that flows from the exercise of constitutional responsibility or obligations by an altogether different arm of the state? Where is the connection?
Well, the magistrate did not exercise did not do what the magistrate should have done.
Yes, that is true.
And what had happened was that the police arrested the respondent and took him to the reception court.
That is true.
Knowing that what would there happen was simply to secure the further detention of the respondent.
So they knew that the magistrates are incompetent. Why should they be blamed for the incompetence of the magistrates? Or maybe let me put it in a proper perspective. Let's go to section 35 of the Constitution. Subsection 1, paragraphs D to F. In that book, it would be page 21. It reads, everyone who is arrested for allegedly committing an offense has the right, D, to be brought before a court as soon as reasonably possible, but not later than 48 hours after the arrest. Maybe we should pause there. What is the reason for bringing accused persons before court within 48 hours? Why does the Constitution, and I'm not even talking about the Criminal Procedure Act here, why does the Constitution require of the police to bring arrested people or detained people before a court of law within 48 hours?
Well, for the courts to determine whether there would be a justification, legal justification for the further detention of the arrested person.
Wonderful. Let's read further because it makes that point. And then E says, the same D is 48 hours or Roman numeral 2, the end of the first court day after the expiry of the 48 hours, if the 48 hours expire outside ordinary court hours, or on a day which is not an ordinary court day. E, at the first court appearance, now this is the Constitution, the supreme law, after being arrested, to be charged or to be informed of the reason for the detention to continue, or to be released, and F, to be released from detention if the interest of justice permit, subject to reasonable conditions. So there's an obligation, a constitutional obligation on the magistrates here. And you've already correctly said for the court to satisfy itself that the person was correctly arrested. In other words, to tamper with the arbitrariness or unlawfulness, if there was any arbitrariness or unlawfulness in the arrest. Now, if the court fails to honor its constitutional obligation to ensure that justice is done, why should liability be imputed to the police? Why should there be joint and several liability?
This is what the judgment found, and the reasons were furnished for that conclusion. Then it will be up to the Constitutional Court to decide whether that judgment in that respect is correct.
I want us to debate it because I want to be satisfied that as the second senior most judge of the SCA, if appointed, you're going to make sure that the Constitution is always factored into the development of our jurisprudence. Remember some years back, there was a concern that the SCA focuses more on the common law and pays very little attention to the Constitution. So that's why I want to engage with you. Why did Section 35 of the Constitution not inform the decision that you took here? You were not alone, you were with Justices Ponan and Busielo. Why did you not have regard to the constitutional obligation of a court of law and hold the Minister of Police liable for something that the police could neither have contributed to one way or the other? They don't decide together with the court what to do. They can testify, they can suggest, but the final word is that of the court. Why were the constitutional obligations of the magistrate not taken into account here?
I take your point, Chief Justice, but the fact of the matter is that perhaps regrettable, Section 35 of the Constitution was not adverted to when this matter was argued
Yes.
and adjudicated upon.
Let me tell you another problem that I have in relation to that matter. It is this. There is an issue of legal causation involved here. And our jurisprudence says Mashongwa is one of the authorities to be had regard to, the Constitutional Court decision. It says the imputation of liability can be tempered with on the basis of public policy. And those public policy considerations are informed by the values and the norms of our Constitution. And the values and norms of our Constitution that are relevant to this case are accountability and responsiveness. Meaning, where one arm of the state bears the exclusive constitutional obligation to do something and it doesn't do it, because it must account and it must be responsive, you have got to factor those constitutional values in reflecting on how far the imputation of liability has to go, in considering legal causation, in other words.
Yes.
So that must say to us, how can you then hold the Minister of Police accountable for something that a functionally independent arm of the state, another functionally independent arm of the state has done? How in law does it work?
Chief Justice, I'll keep on harping on the same response, which is that this is how the SCA decided the matter.
Yes.
And perhaps it would be up to the Constitutional Court to make a determination as to the correctness or otherwise of that judgment in relation to that aspect. I'm aware that there is a case pending before.
No, we can't discuss pending cases. Just maybe we should say nothing about a pending case and just focus on this one. Do you still believe this decision is correct? Or do you reserve your comments?
I would reserve my comments to have more time to
reflect
on
properly.
That. Yes.
Okay. Now, I also would want to touch on the issue that Mr. Fourie raised. Don't you think the time has come to merge the Supreme Court of Appeal with the Constitutional Court, in line with what you alluded to in your previous interview?
Chief Justice, one would have to give consideration to the current state of the law and then determine whether that would be the way to go in the light of the provisions of Section 167(3) of the Constitution, in the light of the fact that during my acting stint at the Court, I got a sense that most of the litigants who are unsuccessful at the SCA come to the Constitutional Court as a matter of course.
Yes.
On the basis, if they can't find a constitutional issue, on the basis that their case raises a point, an arguable point of law of public importance.
Is the
And that determination, unfortunately, has to be made by the Constitutional Court at the end of the day, whether the case in question falls within the purview of those constitutional provisions or not.
Do you get a sense that the Constitutional Court is coping with the workload, or is it just too heavy a workload for that court to handle as presently constituted?
Well, it's a heavy workload, and you know it's something that which is worth looking into to see how best to deal with the situation given these constitutional provisions.
As an aspirant leader of the second highest court in the land, don't you think the public would benefit better given the inequalities in this country? If instead of having to move through so many layers before you get to the highest court, you would simply have one layer above the High Court, and there would be a merged Supreme Court of Appeal and Constitutional Court, considering how expensive it is to litigate?
Yes, it would, Chief Justice, and in fact it would also ensure that, you know, finality is reached in litigation.
Yes. I got a sense from what you said and from what Justice Myers, President Myers said, that you know the people who are making life unbearable for junior colleagues at the Supreme Court of Appeal. Am I mistaken?
Well, I've heard, I have no personal knowledge other than from what I heard, and I wouldn't want to say, you know, it's so and so and so and so when I do not have personal knowledge.
No, I wouldn't.
One would have to,
Yes.
you know, to investigate, hear from the, you know, colleagues who were at the receiving end of the unacceptable conduct and take the matter from there.
No, I wouldn't ask you to name them, but based on the engagement that I've had with some of those colleagues after President Myers' last interview, some of them volunteered and came to see me. And they told me who the colleagues are who has caused them a lot of grief. Unbelievably unprofessional conduct, the kind of arrogance that you can never associate with the judiciary. Are you sure this is not known? Are those people not known, even if you don't have to name them?
From what I've heard, you know, the people are known, and especially in relation to the incident which is reported to have occurred 2-3 weeks ago. I was not there.
Yes.
I'm not at the SCA. What I know is pure hearsay.
Well, what should be done? Should these people be named and shamed? I mean, this has been going on for years now. What should happen? I thought whether you're a judge or not, you know what it means to be courteous to a colleague. There are moments of weakness, granted, but if it becomes a pattern, you are known to this person who has no respect for certain people. Even if you disagree with their judgments, you won't tell them, you'll just pen your own judgment. Should they be named or shamed, or is there a better approach?
Naming and shaming, I would suggest should be done as a matter of last resort.
What should be done now? because they know it's wrong. It's been spoken about. Justice President Maya, when she was interviewed, it came out, but it's not stopping.
Well, I would suggest that, you know, the judges of the SCA as a collective, including the personalities who are seen as culprits, should be afforded an opportunity to try and deal with these challenges internally. And if all fails, then one could then consider escalating the problems.
How is it to be dealt with internally? Do we teach them manners all over again? Something that seems to be so basic. How is it to be handled? How do you help a person out of rudeness?
You know, it may be something basic, Chief Justice, but one needs to point out to the people that, or colleagues, that this sort of conduct has no place in the judiciary, and let them continue with that conduct at their own peril, so that they cannot be heard to complain that they were not warned, so to speak.
Finally, Article 11(1)(e) of the Judicial Code of Conduct reads, a judge must avoid any personality issues with colleagues, lawyers, and parties, and seek to foster collegiality. Does that have any bearing on what you have heard some of those colleagues do to their colleagues?
It certainly does, Chief Justice.
Would you consider reporting them?
This has been, you know, the long tradition of the judiciary. Yes. That's why many years ago, or centuries, one of the Lord Chancellors said that, you know, I want all my judges to be gentlemen. If they know a little bit of law, it's all the better. And that statement sought to underscore the importance of character.
Yes.
Character is important.
I mean, it would be understood if a colleague loses it once or twice, but if it becomes who you are, to the detriment of particularly junior colleagues, then it becomes a problem, doesn't it?
Certainly it does, Chief Justice.
And can we get an assurance that you are going to tackle it head on, obviously under the leadership of the President, if appointed?
If I'm appointed, I've said earlier on during this interview, I would be happy if we were given an opportunity to endeavor and deal and resolve these things internally. And if appointed, then I would go back to the SCA and make it clear to colleagues that this is the undertaking that I made to the Judicial Service Commission, and that I would like to see to it that there is an end to this type of conduct. Yes. And that colleagues who persist must know that they do so at their own peril.
Yes. Thank you very much, Justice Petse. You're excused.
Thank you, Chief Justice.